My name is Don B. Pioletti Jr., and I'm a partner in the law firm of Pioletti Pioletti Nichols. And I'm here today to talk to you about the process of probating estates. Now, there is a legal definition for probating estates. The legal definition is the formal legal process that gives recognition to a will and appoints an executor, or in the case where there is no will, an administrator, who will administer the estate and distribute the assets to the intended beneficiaries. The purpose is to transfer legally a deceased person's assets to the beneficiaries and to pay all of his last bills. The initial conference with the client, who supposedly is the executor named in the will, should take place in a short period of time, not to exceed 30 days. And the reason for that is because under Illinois law, the will has to be filed within 30 days after the deceased person has died. The will should be filed in the county in which the deceased person was a resident, not necessarily where they died. The executor comes in and talks to the attorney. The attorney will then prepare a petition, and he will prepare an affidavit of heirship, and he will also prepare a bond and oath. The bond and oath needs to be signed by the executor, and he needs to take it with him and have two witnesses sign it, verifying or vouching for his trustworthiness in handling all the responsibilities and powers that the executor will be given. And he brings that back to the attorney. The attorney files the petition for the probate of the will, the affidavit of heirship, the bond and oath, and the will, files those in the circuit clerk's office, and that opens the estate. The judge, in turn, will look at those documents, especially the affidavit of heirship. And if he determines that everything is in order, he will then sign an order declaring heirship. He will also sign an order admitting the will to probate and appointing the legal representative, which would be, in this case, with a will, the executor. He will take those documents, deliver them to the circuit clerk's office. The circuit clerk then will, in turn, prepare and seal a Letter Testamentary. That's what it's called. That's what the document is called. The Letter Testamentary will then be sent to the attorney. The attorney will give it to the executor, and the executor will then have the power and responsibility to act in the place of the deceased person. He or she will be able to, at that point, have investments released, have real estate sold, and all the assets sequestered with that Letter Testamentary. And so he will open a bank account for the estate, and he will deposit all of the assets as he receives them into that bank account. And if there's real estate, he'll be able to sell the real estate and have the real estate proceeds put into that account as well. So that's kind of how it works. It's a 6-month process. The attorney during that 6 months will have to file a notice, a claim notice. He'll put that in the newspaper in the county in which the deceased was a resident at that time. That gives notice to all the claimants, all the creditors, people like that, the notice that they can file a claim against the estate. A lot of times that's medical claimants, sometimes it's loan claimants, things like that. They will file the claim in the estate with the clerk. They will also send copies to the executor and to the attorney. And then it will be the responsibility of the attorney to determine if those claims are valid. If they are valid, then the executor will have to pay those claims out of the assets that the executor is receiving during that 6 months. One of the big questions that people ask is, can I receive any assets before the 6 months? And the answer to that is yes. As soon as the estate is opened, the executor can determine how much and which assets can be distributed to beneficiaries, keeping in mind that there are going to be probably income taxes to be paid on behalf of the deceased, the last income tax that the deceased would have paid had they remained alive, and also unknown creditors that may pop up during the 6 months. But generally, the executor at that point can distribute 80% of the assets to the beneficiaries that are named in the will during the 6-month period. Another question that's asked, big question, how much And how expensive is doing probate? Well, the answer to that is, in our case, we usually charge generally between $4,000 and $8,000 for the whole process. And that would include the court costs, notice fees, all of the costs. Occasionally, and under certain extraordinary circumstances, that would be expanded because in some cases beneficiaries fight over the assets. Or in some cases, someone will contest the will. So there are all kinds of possibilities that could enlarge that $4,000 to $8,000 attorney's fee and court costs. But generally, they run $4,000 to $8,000. At a certain time, when the executor has gathered up all the assets, he needs to prepare an inventory, give that to the attorney, and then the attorney needs to send that out, that inventory, to all the potential beneficiaries. And prior to closing the estate, the executor, with the help of the attorney, needs to prepare a list of all of the assets that have been received, all of the expenses that have been paid out, including the claims, and then a recapitulation showing what net assets there are after all expenses have been paid, and then finally a list of all the beneficiaries and how much each one is to receive or has already received. That's called the final report. And that final report needs to be filed with the court. The court looks at that final report, and if it is determined that everything is in order, the court will issue what is called an order of discharge. And that order of discharge basically closes the estate and terminates the responsibility and all of the powers of the executor. So that's the whole process of probate from start to finish. Generally, estates, once started, take a little over 6 months from opening to closing. And that's about it. Our firm has done estates. We were established in 1938 with my father, Don B. Pioletti Sr. We've been on estates ever since 1938 and probated estates ever since that time. Very little has changed other than the fact that in estate taxes, there's a $5.5 million exemption now, where you don't have to pay taxes if the estate falls under that. 30, 40, 50 years ago, the estate tax exemption was about $585,000. And so it's grown ever since. So most people that we handle estates in don't even pay estate taxes. They pay income taxes for the estate, but that's about it. So that's probate process in a nutshell. If anyone is struggling with trying to figure out if they need to do probate or struggling with the probate process and don't have an attorney, we would be glad to help and answer any questions you may have.